In every society, lying is regarded as a moral wrong. But when a person lies on oath, there could be criminal repercussions to this conduct. Today on Law Express, we take on the topic perjury. My name is Noella Seidu. You just joined Law Express. Stay tuned. Don't go away.
Randolph Chumesi Ankra is a private legal practitioner who enjoys hanging out with friends, reading, gardening, playing video games, and watching football. Yao Sampa is a private legal practitioner who finds relaxation and enjoyment in activities outside of his professional life. His hobbies include playing chess and exploring new destinations through travel. Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
Perjury is a legal construct, and then which simply means, for the layman's understanding, speaking untruth or telling lies under oath. So in effect, if you appear before a court or a body, a public body, and you make statements either in writing or verbally, which you knew at the time you were making those statements to be false, then you are putting yourself in the realms of perjury. Now, from the laws of Ghana, perjury has been made a criminal offense. And you can find it, I think, in sections 210 and sections 211. One creates the offense and one defines it. And by the definition of the offense of perjury, it is not every statement made which turns out to be false that will amount to perjury, unless in some specific instances and before some specific institutions or persons. So under our laws, for instance, you can be committed for perjury if under oath you make a false statement before the president, before the court, before a commission or a committee of inquiry, and I think any other public officer. This is the persons or institutions under which or before whom, if you take oath and make certain statements that turns out to be untrue or false, you can be liable for the offense of perjury.
To unpack this, probably we need to approach it from what an oath is.
It is interesting the context has been laid by my senior here. The interesting thing is the wording. You know, English has evolved. So the etymology of the word actually is Latin, which is to tell us swearing, knowing it in two elements, knowing it to be false or having no reason to believe in its truth. So one is a definitiveness that you know that what you're saying is wrong. And the second element is speaking to the reasonability of the fact that at the time you were saying it, you couldn't have known that it is reasonably true. Usually when you go to court or in any legal proceedings, the person who is a witness is required to whatever statement they are going to make, that they take it on oath, say they will say the truth, the whole truth and nothing but the truth. In that indication to say that whatever you're going to say, to the best of your knowledge, is what the court should rely on in making of a decision. Once you make an indication that, whether an affirmation, so in documents as well, so two elements, whether or not it's verbal, so verbally, if I say something I know to be a falsehood, or I say something without believing in its truthfulness, and I do it under oath, whether verbal or written. So if I have an affidavit or or I have a document, say a passport office, which is a public office, and I fill a form and I sign by declaration or affirmation to say that everything I've stated in the document is true, but proves not to be, then I would have found myself to have committed the offense of perjury.
So bringing in more examples to support what you just said, when you go to apply for a TIN, that's individual tax identification number, you are asked whether you already have an issued one.
Right.
Then you take yes or no. In the end, there's a declaration, and that is an oath.
Yes.
Where once you take and sign that everything you have represented or the information you've offered is true to the best of your knowledge, blah, 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 then, okay, you are bound by the same terms. That could easily bring you within the space of perjury.
Yes.
But I was talking about oath simpliciter. What is an oath? In simple terms.
Right. So an oath, there's an oath act, but the generality of an oath is basically swearing.
Yes.
The
Or
idea of
affirming.
swearing or affirming something to be true or something you would abide by. So an oath of an office particularly will say you are committed to the office, you do the dictates of the office, you protect the constitution and the laws that bites the. So it is an affirmation or is a swearing.
More like a pledge.
Yes,
To
a pledge.
do what you're promising to
Right.
do.
Exactly.
Right. Yes.
Or you are agreeing to do, and that could be to serve to the best of your ability or to tell the truth and nothing but the truth.
So let me just, before I go there to give, let me take you back to our rural settings.
Yes.
Where before we had these formal laws and formal court systems, where there was an issue, you notice that maybe the fetish priest or the fetish priestess will be called to invoke the gods for someone to swear on the gods that whatever it is you're going to say is the truth.
Yeah.
So when a person is able to take the oath or invoke the gods and speaks, it is believed that whatever the person has said is true, because then the learning is that if whatever you have said in the name of the gods turns out to be untrue, the gods will strike you down.
Yeah.
So in a sense, when you give an oath or when you take the oath, it's a communication to the public that you are promising everybody and you are invoking a certain divine guidance or witness to testify to the effect that whatever it is you are saying is true, and that if it turns out to be otherwise, the consequences from the divine should be visited upon you.
But it's the same thing as what pertains to the court system. I mean, it's still the invocation of a deity where you choose to swear on the Quran or you choose to swear on the Bible or the cross. So it's the same deity invocation, and I'm sure the biblical understanding is following from the precedent of Ananias and Sapphira, where if you lie, you're supposed to be struck dead immediately. But more and more people are opting for that. I haven't seen anybody yet struck down, because the interesting thing is at the end of the vow, so help me God, most of the time.
Yeah.
So when God doesn't strike the person, why is the state taking it upon themselves to play God?
I guess that's the essence of it. As was said, if I invoke a god, then the idea is that the god then sits in justice.
Yes.
And arbitrates the matter or judges the matter.
Yeah.
In this case, we're before a neutral third party in a judicial process. So the provisions
So why are we
of
not
perjury.
swearing by the judge?
So I guess the provisions of perjury is to the same effect that if I do lie, the process has made upon itself a punishment for not speaking the truth, in as much as the gods would have.
That will work more with affirmations,
So-
because at that point there's no deity involvement.
So if you look at the policy rationale behind perjury, I mean, as we have all indicated, the notion of taking oaths is birthed out of the belief that so long as the person has sworn by his belief or convictions, then they are likely to speak the truth. But experience has taught us as lawyers that, and especially we say we are in the New Testament era, so
Yeah.
God
Grace.
hastens slowly
Grace.
in his vengeance or whatever, against people who lie. So we all take advantage of the grace. But if you look at the policy rationale underlining perjury, you notice that in as much as society wants to give witnesses and persons the free will to tell their versions of events without fear of repercussions, there is also this likelihood that people may make up stories which may end other people in trouble. You can lose your property, you can lose your liberty. So in such
even your life, in some instances.
And you see, especially we are lawyers, so let's even use the example of the courts. When a person comes to court, there is an issue at stake. The judge determines the issue based on the evidence that will be put before him or her at the end of the day. The judge, like he said, and as has been said famously, you and I were not there. The judge was not there when the event happened. Your lawyers were not there when the event happened. So we are all bound by whatever it is you say before the court. But you have also taken an oath that whatever you have said is true. So it carries weight. Now, if it turns out that what you have said is not true, what you have done is that you have purged the public conscience, more or less.
And misled the entire
society.
Absolutely.
Yeah.
And that based on that misleading information, someone could have lost their life, someone could have lost their property.
Somebody actually could have.
Yes.
Yeah.
And because of that, there should be, at least in our lifetime, we can't wait for the deity to punish you. In our lifetime, you must see some punishment to deter other people from also following suit. So that is the policy rationale, one of the policy rationale that underlines the offense of perjury. And that is why, even though you may take your oath, if it's found that you have lied, you will not wait for your deity, the deity you invoked, to come and punish you. You have to punish you for it.
This oath is actually for your own self, because you are putting yourself on the line, saying that, believe me,
Yes.
and if what I say turns out to be false, hold me responsible for whatever statements I make.
Absolutely.
I mean, there's nothing that stops you under cross-examination or in giving testimony before a court where you're on oath to say, I don't know about this aspect. So it gives, because of the consequence, when you are being, examined and you think that they are going into areas you're not aware of, instead of pretending to be all-knowing, you can actually directly say, look, I do not know this bit, but this is what I know. You get the point?
Yeah, I get
Just so you protect yourself, because you can't possibly know everything under the sun, right?
Yes, but you see, I like the angle you're taking it from, but it's discounting the human factor and the interest we have in cases that we are called to testify in. You see, when you are called as a witness, sometimes you forget the fact that you are there not to assist the person who necessarily called you, but to assist the society arrive at the truth.
Absolutely.
But because you were called by, Noella has called me to come and testify. In my mind,
I should say something.
Everything that I say should support her case. So even if a question is put to me, and I do not have the answer, or is contrary to what
you try to process,
I'll try to
what
process
is likely to help
and give an
Noella's
answer.
case.
That's what you do. Forgetting that you are not there to necessarily help her case, but to assist the court make a truthful determination. So that is why sometimes people are unable to say this one, I don't know.
Yeah, because there's no shame in actually admitting that you don't know.
As he's saying, I don't think it's an element of shame rather than aiding and furthering the cause of the one who called you or the one you prefer among the parties. So it's more like, okay, and if you look at, even in Bible times, false witnesses is always been mentioned in some sense, so there's always an idea that a witness may be false to the extent that they would prefer a narrative they know to be false, or they couldn't reasonably have believed it to be true. So I think that generally it's not shame per se, because of course if you don't know, you don't know. But I think it's more of a question of, I am intended to aid a party further their case or their cause. But I think you asked a very important question as to why do people not seem to fear, or why do people not seem to be afraid, or why is it not such an in thing that when I go to swear an oath, I'm signing something, I'm bounded by the limit of truth, knowing
because
that
they are just looking at what they intend to achieve,
Is the
and
interest.
not the consequence.
But is it also, could it also, in as much as, could it also be a question of the fact that the limits of the law, we probably haven't seen a lot of it, because it's a crime, it has to be prosecuted.
Yes.
And so somebody has to report you to the police, and then the police or attorney general, as the case may be, is the one mandated.
After investigations, they decide whether it is a matter to pursue or not.
Yes. And in the body of crime, in the body of, I like, in the body of crime, have we as a society told ourselves truth matter? So if perjury comes up, we consider it with all the seriousness as much as we will. Especially
because, you know, perjury could arise even in a civil matter. Why wouldn't it be treated like contempt is, such that somebody who is injured or affected by reason of your lies or falsehood and the oath can actually take steps to get you, you know, imprisoned or fined? Because, Mr. Ankara, I'm looking at it like this. You are two civil, like it's a civil matter, two private individuals. You are litigating, okay? Somebody comes to give false testimony. They rule against you. Maybe your company goes down. You go through a lot. Probably in the course of all of that, there are contempt proceedings brought against you. You are incarcerated and all of that. And then you find out that the whole thing, the foundation for everything you've suffered was based on somebody's false testimony. You report to the AG's department or to the police. Nobody acts, nobody lifts a finger. Do you just go like that? This is work. It is. Of course, you can still follow civil channels, but you can never be brought back to where you were before. And where lies the issue of, you know, deterrence and all of the other things.
So that is why, as I indicated, the authorities are still not at them on what should be, because, like you said, to one person's mind, it could be a case of contempt if you lie to the court. Because anything that undermines the administration of justice, don't forget, the aim of the court is to arrive at what is just. So if you give misleading information to the court, and the court acts on that misleading information.
What if it's not a court?
No,
some other public institution. Because courts, there's contempt powers that you can stretch to cover it. What about you go to the passport office, you lie that this is your name, date of birth, mother's name, everything else, and then you get a passport. Later it's found out. Now the police has to prosecute you, right? But they are not taking any steps.
In that
you've
case,
injured the whole of society because this is an ID you've carried that belongs to the state. And you've used it to do other transactions and nobody says anything. That's my point.
Who suffers in such a situation is the state.
Yes.
And the state is the one vested with the prosecutorial powers.
Yes.
Through its attorney general. So if the injured party in this case, which is the state, opts not to prosecute you, I mean, you should pray and thank God and walk away.
Where is the fairness in it then? Because what happens is, if another person follows suit, it should be the same treatment because the state should be fair and objective.
So if I may, without laboring in cases, because I know this is not a legal, but there's a classic case, I think it's Republic versus Norte.
Yes.
2014
decision that actually discusses this classic debate around what happens in a civil suit, and is it only the AG, as the case may be, that will prosecute the crime. I think that the decision, it discusses a Supreme Court case on the contempt and distinguishes it quite carefully from perjury. I tend to agree with the decision in some form. You see, generally, if it's a prosecutor's witness, you have a claim in tort already in malicious prosecution.
Yes.
You actually may have other civil claims as it may relate to whatever the subject matter of the perjury is.
Yes.
So in terms of, because it's defined as a crime in our law books and the basis of criminal law, I think that the heart of the decision is that once you're labeled with a crime, you must be giving a fair notice to defend yourself, which is a constitutional provision under Article 19.
Yes.
So ultimately, you can't say that I'm found guilty of a 211 when somebody initiated as a process within a civil suit. it must originate. I must be charged with the crime. I must go through the rudiments of
But
criminal
that's what
law.
happens with contempt.
But you see,
Yes, it's not clear-cut criminal law hardcore. But it's quasi-criminal.
Yes.
And it's the same procedure, same standards. So my point is, it can be treated in the same manner. Where you are officially charged, probably this time you have to be served with the application, so you know that, look, you've been summoned. You show up in court, you have an opportunity to defend yourself, explain yourself, whatever it will take, before judgment is given in the matter at the end of proceedings. Hold your thoughts, gentlemen. We'll go for a quick commercial break. This is still Law Express. Don't go away.
you know, we've talked about perjury and what perjury is and how you distinguish it and whether a private person can institute proceedings for perjury. Now, one thing I need to put across is that when you give an oath, loosely, you are a witness. You've testified to something. And if you look at our laws, the qualification for being a witness is competence. When we say competence, we are not talking about the competence we are used to.
Professional competence.
We are used to know. We are talking about certain competence of mind to be able to testify. So that's why if you look at our laws, a child can even testify.
Mentally challenged
person can when they have lucid moments. So the law looks at the competence of the person. So the question is, if a person is not competent within the eyes of the law, can they commit perjury?
That's a good one. Of course not.
Can they commit
Because
perjury?
you first have to know the nature of the testimony or the responsibility on you. You should understand what is required of you, and you should be capable of fulfilling that obligation of telling the truth.
Exactly.
So if you do not understand it, where's your intention to
Because
perjure yourself?
How do you say to the law? You are not compos mentis. You don't even have the mental capacity to even lie or to even speak the truth.
I mean, you just talk, but then you don't know if it's true or not. And you should have the intention to lie, because I don't think accidental lying, as in at the time you believed that to be true. If subsequently you find out that wasn't true, at the time you made a statement, you were not lying. That was what you believed in.
Yes. That's actually the second element. That's why I've been emphasizing on that. Is either you know it to be false, or you did not believe in its reasonableness to be true.
Yes.
So assuming at the time I was making the statement, I truly believed it to be true.
100%. Based on what was available as the facts to you.
Then I may not have perjured myself. There's a Supreme Court 64 decision that sort of sets 3 key elements as a requirement that those 3 things has to be present for the crime or offense of perjury to have been committed. We said it. The first one is took an oath or an affirmation. And it's careful to say or an affirmation, because we've said in this conversation that it's not only verbal. Sometimes as in your written...
Well, even in court, you can verbally affirm.
I mean, you affirm your belief, your faith, or by your conscience.
So you are not Christian, you're not Muslim.
Yes.
You live by your
you're
conscience.
not Catholic, because that's where the cross comes to play. But you are affirming by your conscience, so you're giving your word as your bond.
Yes. So whether you take an oath or you do affirm, that's the first key element. So if we're talking about perjury, it must be in the light of an affirmation or an oath.
So there must be a positive statement of some sort.
Yes.
Great.
The second element the court discusses is that he made or verified the statement upon the oath or affirmation, which is then the positive statement.
Yes. So you must actually say something.
Yes.
Yes.
You know, something that is verified. And the third element becomes that statement you knew to be false in material particular. And I think that's also important.
Yeah.
That usage of the word material particular, or had no reason to believe in it being true. So I guess the ultimate question then becomes, what is material particular? You know, to what extent do you say that the whole testimony, to what extent have I perjured myself? If the defining is material particular, to what extent is materiality?
So the courts, like every other institution, or even human nature, we all know that it's unlikely to have 100% reproduction of an event. So if we all sit here and something falls over, somebody pushes it, Chumesi might say that, okay, so-and-so was walking and pushed this thing down intentionally. You might say he bumped into it and it fell. And somebody else might say that he picked it and put it on the floor. So the materiality is the difference in between, right? First of all, what is the percentage of this information that actually corroborates the actual thing that happened? Everybody's talking to the fact that it was down. Now, as to whether you bumped it or you did it intentionally is a matter of probably law to confirm. But this guy who says that you picked it and put it on the ground has departed materially from the event, right?
Okay, so let me just look at, if you look at that, the third element of the crime of perjury, because, and I say element because by our laws, when you are charged with, let's say for instance, that's why lawyers, you find lawyers saying that you see the ordinary Ghanaian will say, oh, why are you defending this criminal? He killed somebody. Oh, he's a murderer. And the lawyer will say, no, he killed, but he hasn't murdered yet. Because murder is the offense and it comes with its own elements. So I may have killed you, but I have not committed murder. So I may have told a lie, but I have not committed the offense of perjury per se. You have to go and look at the elements. And now the third element is saying that at the time where the person, after the two elements have been met, which is you took an oath and you have made the statement whilst under oath, whether at that material point in time you knew that what you were saying
to be false.
To be false, or it was false. And that is why I'm saying that that will be a determination. So for instance, that will be a determination for the court to make, or for defense counsel or whichever lawyer to be able to elicit that.
How do you prove that in somebody's mind he knew that what he was saying at the time was wrong?
So it comes to intention. And then section 13 of our act tells us how...
But you must act on that intention. If at the time, how do you read somebody's mind to see that he knew? Unless the person probably had spoken to another person, or there's a recording that shows that you were both trying to massage the information. It is almost impractical. Like, how do you read? Even the devil doesn't know what's in the man's mind.
No, is it not a fact that of all crimes, you need two basic elements? You need the act itself, but you also need you also need a certain sense of intention.
So how do you get the intention in something that speaks to the person's honest belief at the time, not honest belief subsequently?
Right.
Because I can believe this today to be green, and tomorrow I believe it to be black, and I'll be right in both instances. But at the time that I made those statements.
And I see, yes, so you have made a statement, two contradictory statements within a space of maybe 24, 48 hours.
But I haven't perjured myself.
So the question would be, when we pick the book at a point in time, is it green
or black?
Or maybe
and then we have to ask ourselves another question. Was there a point in time where the book was black?
Right.
And does that point in time falls within the time when you saw it?
It could even be beyond that. There could be a defect in my eyesight.
Which then brings to the legitimacy.
And then comes to the intentions and all of that.
No. That is not about intention per se. You see, the idea is that the thing remained green all through, but then you perceived it to be black based on whatever could have influenced that. The idea is that you believed, not what caused you to believe.
Right. So yes, I hear you. We're not talking about causation. We're talking about. So you see, to what extent?
I'm not talking of causation.
No, I understand.
I'm talking about how you arrived at that.
Yes, I understand that. I'm coming to the point that at any point in time, the ultimate question is really, do you believe it to be true or is it false? So those are the things. Is it a false statement you knew was false?
So today I believe it to be true. Tomorrow I also believe another thing to be true.
But you actually even brought in a variance that it could be based on your eyesight. So if, for instance, if you are charged, that's why some way, somehow, I'm tempted to agree with the High Court's decision on this matter, that you have to afford the person the opportunity to fully defend themselves. So if you believe that your eyesight is what caused you to believe the book to be green, contrary to what everybody is seeing it as black, you must be afforded the opportunity to put out that defense. At the end of the day, the court will evaluate, because, the reason I brought in the intention, if at the time when you saw it to be green, you reasonably believed it to be green based on your eyesight, then you couldn't have had the intention to even lie in the first place. Because then, that is what you believed it to be.
We sampled people's opinion on the topic, since it looks like we have very, very divergent ideas about this, mainly because it's not a very much litigated aspect of the law. Let's pick their lay opinion as well and continue our conversation.
Okay.
That perjury should be an offense because once an oath is taken, a commitment is made, a commitment to tell the truth. So I don't understand why you know that your oath has invoked consequences if you go against it and would still lie. I think it should be punishable so that it will serve as a deterrent to other people who would want to take an oath and then go against it.
The act of speaking or having the intention of what you are saying, but that thing is not true. Is not the truth. So anybody found in that act should be punished to serve to deter others from committing the same sin.
Perjury is a crime of knowingly making a false statement under oath. It is an offense which can lead to serious consequences.
Perjury can be said to be an act of giving out false information, typically under an oath. It can be a criminal offense because it undermines the integrity of the justice system.
When it comes to constitutional edicts and laws, they are full of potpourri emotions. And in addition to imprisonment, if you lie under an oath, the court can also pose fines on you. And I think psychologically or emotionally, you wouldn't feel comfortable knowing that what you are saying under the oath are all lies. So I think, in addition to imprisonment, the court can also impose fines onto the person lying under an oath.
So I think when someone is swearing under the oath and the person is still lying, some of the consequences the person may face might be a life imprisonment, a fine, or probably a death sentence.
So lying under an oath is a criminal offense, and our advice that no one should involve in it because there are some consequences that you face. Some are fine. You'll be fined to pay an amount of money to redeem yourself. Also, you can be sent to prison for life imprisonment. So I would advise that no one does it.
Right. So in reacting to the statement, I guess one important thing is that I think the general notion is correct, except that the forum matters, and that's one thing. So it's not like when your boyfriend swears to you or you go and cut your blood and do that kind
That's an oath, all right.
Yes. But the law says that it must be before a court, it must be before a public officer. It must
if your boyfriend is a public officer.
The question is whether he gave you the promise in his official capacity or personal capacity.
So
you made a promise to him.
And
he is a public officer.
But in his capacity as
a
what?
boyfriend.
As a boyfriend or as the public officer?
A boyfriend who is a public officer.
He carries two identities.
Absolutely. Yeah. So a public officer, the president, a commission or a committee. So I think the first thing I want to say is that yes, it is with oaths and it is with statements you know to be false or statements you couldn't have reasonably believed to be true, but the forum matters. So that's the first thing I want to point out. Also, in terms of the punishment regimes, I think ordinarily perjury is a second-degree felony, if I'm not mistaken. But where you perjure against in a crime where it's punishable by death.
So, for instance, there are treason proceedings, and this person could be killed.
Yes.
Or punished by death.
Yes.
And then you go and lie there.
Yes. In that case, it becomes a first-degree felony. So those are my two quick reactions. I think I'll defer.
And so you're corroborating the guy's statement where he says you can go in for life.
Yes. So just to corroborate that, yes.
Yeah.
I think that generally the views expressed by the public is quite encouraging. I mean, and having shown that they know that perjury would arise when you lie under oath, I'm sure they all be guided when they find themselves in a situation where they're supposed to offer information under oath.
I'm getting ideas on this topic, okay? You know, when you go to marry under the ordinance, the marriage officer is a public official, especially when you go to do it at the registrar generals of the court. Now you go and then you make an oath to be with the person till death do you part. Now, if at that time you knew that you probably didn't have the capacity to even marry in the first place, or you knew very well that you did not intend to marry this person forever, would this not amount to perjury?
That's not like I vehemently disagree.
Of course, you don't, as men, you don't want that to happen, right?
But I will perpetually disagree.
You don't even care about the circumstances. No. You just don't want it to be that.
It can't
but
be
honestly.
No, but it's an interesting drift. Except that I don't agree it is.
Is it? Okay.
No, but
so
it is an interesting drift.
There being an oath.
Yes.
Affirmation. Okay. Or you want to swear. Okay. You did that before, and we talked about forum. A court. That you're going to be with this person until death. Do you part? So what business do you have bringing divorce?
No, I don't think the declaration that the oath or the declaration the document you sign at the Registrar General's Department has that portion. No, it doesn't have it. For you to make that problem.
But you would have made that oath anyway.
You make oath that you are not married or you are not previously married to anybody.
Yes.
But so it's speaking to the past, not your future.
No problem. Since you don't want it to have that effect, let's bring it back based on your own statement that you have not been previously married. Then you come and declare that you were a bachelor.
Yes.
When you know that you are divorced. That is lying. And this time, once again, you are signing on another certificate of marriage, okay, before a public officer. And that's a state-issued thing with witnesses to somebody's daughter's detriment.
So my initial reaction would be,
I understand that
there's actually a course of action.
Avenue, yes, in matrimonial courses.
Absolutely.
But I'm talking about perjury because normally with all of these other ones where you perjure somebody, there are still other avenues that you can explore. But the question is, shouldn't it amount to perjury?
I don't think that in such an instance, perjury will arise.
This man doesn't just want that.
No, because
he doesn't want to hear about it within the context of marriage. That's his problem.
No, not that. You see, the reason why I don't think it will arise in this context is because at least the person was candid that he is a bachelor. As to what his understanding of a bachelor is, we don't know. Because at the time, the question will be, at the time when he was signing the document, he was not married.
No.
But if there was a provision for divorce,
there is
and
always.
You knew that
there's an opportunity for a widower,
then
divorced.
But the question is, who is a bachelor? Who is a bachelor?
That is somebody who's
who's a bachelor?
Who has previously not been married.
Who is a bachelor?
And you and I know that, especially when it comes for annulments, you are reinstated back to where you were before. So if you're divorced, you still remain a divorcee. If you were a bachelor, the fact of the cancelled marriage brings you are restored back to being a bachelor. Because let's look at it on the flip side. If you're a bachelor and then they wrote the divorced person there, you wouldn't even be happy about that. So why is it that when you're divorced, you don't want that and you're like, okay with being called a bachelor? You've been mislabeled.
Yeah, you've been mislabeled, but I don't think that in itself.
So intentionally. So you see, we talked about the intention, the intent. You know the difference. You are a lawyer. You are Mr. Chumesi Ankra. You know the difference in these words. Then you go there. You had the option. You knew that, look, this thing as a practicing lawyer, you have seen so many marriage certificates. You cannot lie in your mouth to say, I don't know the difference between a widower and a bachelor. And so, yes, though I'm a bachelor, I chose widower.
Okay, Noella, let me react to it. If you read Section 211 carefully, I think that there is some connotation to a judicial process, right? And so yes, the forum matters, and I think I've emphasized the forum
for marriage.
I hear that, but is that typically a judicial process?
What is it? Why is it that when you decide to terminate the marriage, you come to the courts again? Because I'm not talking of a customary marriage where you stand before the family and you promise, then you give the ring and you say you love the person and protect her forever. Once again, forum. I'm talking about marriage under the Part 3 of the Marriages Act.
No, I find your question interesting in the light of perjury, but I just think that the proper forum and the proper course of action will be in family law.
It is there. No, but even together with that.
But even in that, if I declare that I'm a bachelor instead of a divorcee, it's not even a grounds for divorce. So there's no punishment attached to that.
Who says it's not a ground?
In fact, there's
it's
no
a ground for annulment. You could have been a thing of fraud. If it mattered to your partner, then you must be a bachelor.
But when I'm filling the form, you're supposed to sign. You would have seen that I've labeled myself as a divorcee and went ahead to sign. So
listen,
how then do you come back and say that?
That is if the person can read. If your spouse is not illiterate like you and you are the big lawyer and then you misrepresent your label.
We will continue this conversation.
No, this is a different angle to the conversation. But I find it thought-provoking, except that, as I'm saying, I tend not to be too sure whether somebody should be prosecuted because their bans or their marriage vows.
Listen, the fact that there's a potpourri of options in the law for you to choose from, okay, that fact does not debar you from choosing which one you prefer.
No, I hear you.
So yes, you can have other options within the law.
It will be good to
seek compensation.
It will be good to see.
You may have other options under the Matrimonial Causes Act, but if I choose to go on the path of perjury, because I don't want to just annul the marriage and collect compensation in a lump sum, but I want you to pay for lying to me.
Go to jail for
and for deterrence. If in the same way we can bring people,
it will be
interesting.
Because, like I said,
liken it to bigamy.
Yes,
that's a criminal matter, but you still have an avenue in the Matrimonial Causes Act to terminate the marriage, right?
In fact, you see, in that instance, the bigamy example, the second marriage will even be invalid.
Yeah.
Yes, but still, the person can still go in, and that doesn't also stop the first spouse from also initiating some action under the Matrimonial Causes Act to extinguish the whole thing because you're a liar.
Yeah.
Do you get my point? So this is whole. If bigamy can coexist with divorce and other things,
no, I hear you.
Why can't perjury also coexist? Such that I don't want to leave you, but I just want you punished for perjury.
No, but you see, this will be a conversation for another day because and like I said, my perpetual position will be that
it cannot be
perjury. Can't you take your spouse up and then bring the person under the proceedings for bigamy and still decide that after they've punished him and he's gone to jail and come back, you welcome him with a party and you continue your marriage? It's just his first warning. You don't want to end the marriage.
See, the law lives in culture, and I guess that in as much as I hear the text of the law, I'm struggling with its practice.
Well, the implications.
Its practice in terms of how you would actually make such a cause of action.
Yeah, even when you go for maintenance orders, some people think it's enough to end the marriage because they will feel you've embarrassed your spouse, right? So you can imagine getting your spouse jailed for a criminal matter, but then coming back.
In fact, even if you report your spouse, you're not even coming back to the house. I mean, and see, practically,
you can reconcile. Don't worry. After jail, you reflect.
No, the reason I made that point, if you go to DOFSU, at any point where a complaint has been lodged, the marriage has broken down beyond reconciliation.
Not necessarily. I've seen people go to DOFSU and come back happily.
Or people actually even divorce and come back. Yeah. But I'm saying that at any point where you see one take that advanced step to go and initiate criminal proceedings, then in their minds,
there's something about the marriage
act.
It's
not always criminal proceedings. Sometimes, people go there for protection orders and all of that. So it's not like you're trying to get a person jailed at every point. You could just go for, some people go there just to get the other spouse on, one.
Notice.
Yeah, that the next
the point is, some people go there with what you said, their plan is to go and maybe show him shaggy small so that he can sit up.
And then,
but what they don't know is that the law is not giving you shaggy. The law has an end. And the end, some of them, when they realize this is what the end is going to be, they pull out. Because they started without knowing
they
that
no longer offer their testimony as a
so that one.
No, but your question will be interesting to test.
To explore,
it will be very interesting.
I'll be glad to be part of that.
Yeah, it will be
perpetually. I'm in perpetual disagreement.
It will be a very interesting.
No, he's just biased against the whole thing. Okay,
it will be a very interesting.
It would be for great learning, right?
Yeah.
We'll go for a quick commercial break. When we return, we'll try to take on some social media questions that came through. With limited information, of course, we'll try to answer it to the best of our capability. Yeah. This is still Law Express. Stay with us.
I testified against a colleague at work in a matter I did not follow. I just wanted to go with a side of the story that will get him fired. He is very annoying and even eats people's lunch. The committee is about to take its decision, and I feel guilty for what I have done. Will I be punished for perjury if I confess?
The challenge with the question is we are not sure which committee. So we are not sure which committee it relates to, whether it's a committee, a commission of inquiry, a committee set up by the president or set up by parliament. We don't
Labour
know.
Commission.
Labour Commission, or any public institution, committee set up by a public body. So I want to believe it is a private, it's a corporate committee, maybe going into disciplinary committee, going into to ascertain whether a colleague has misconducted himself or otherwise. So if it's purely private, then the issue of perjury will not arise necessarily.
So in this case, you're just a simple, straightforward, unsophisticated liar.
Who
And
testified based on hate.
you have committed a moral offense and not a criminal offense. So he's asking what to do.
So he should just, I think,
You can withdraw your
if
testimony.
the committee hasn't come out with this decision like he says, he should just go back or write it and tell them whatever she said is not true.
Yeah,
But
you
if
might.
it had,
Yeah.
if even the committee had come to an end,
She can
I think
still-
that with the guilt, you can go back and say, you know what?
So you don't face any criminal sanctions or prosecution, but you would face judgment regardless.
It's co-
I mean, this
conscience.
guilt is just the beginning. Apart from your conscience, which you are dealing with privately, you would have to deal with the rest of your colleagues. And now
Absolutely.
everything you ever said will be vetted. Like,
Absolutely.
everybody's going to wonder if you were even truthful. Because to go before an entire panel or committee and be bold enough to lie.
So you see why it is important. This question, so it buttresses the reason why we should have perjury as an offense, because it's someone who was able to go and testify against a colleague because the person eats other people's lunch.
And it's annoying.
Just because of that, and the person is annoying. So such a person, if you are put in the box in court,
They say
and
this.
he or she is called to come and testify against you, you should know you are going in.
And especially if his testimony borders on somebody's liberty or his own liberty.
Absolutely.
Such that maybe if he said the right things, okay, he'll go home.
He will not
Lie
even think
through
twice.
it.
He or she will not even think twice. And even if they could do this because of food.
You can imagine.
If there's a better reward to be gained.
I swore to an affidavit about information I was not sure about. Later, I found out the truth. Am I at risk of imprisonment?
What did you do with your affidavit?
Yes, but I think that the statement says at the time they were not sure, and that's defining in my view.
Yeah.
Because it does not appear to me they intentionally sought to lie.
But
you could have
It
paused
says
and
you were
checked.
not sure.
If you're not sure, then why make a positive
So you
affidavit?
had a reason
You know, but
to not be 100% about it.
yes. So two things. The nature of the affidavit is an oath because the commissioner of oath will affirm to it. So the nature of it being an oath is not in question. Is the nature of what I am not sure means? Is it then a question of I know it to be false, but I'm not sure means I'm not too sure what it is.
If it's false,
It would have been, of course, this is before, after the fact. It would have been better you checked. But having positively gone ahead to, now it comes to the fact that can we really impute a clear intention that not being sure meant, and making a statement meant that you knew reasonably, you couldn't have reasonably believed in its truth. So in which case you will be guilty of perjury. But if it is deemed that not being sure under the circumstances, it was reasonable to infer the conclusion you came to, then I don't think that you would fall square on perjury. So
at the time you were not sure. Why make
is
a
the
positive
totality of the
statement regarding something
is the
you are not
totality
sure
of the
about?
circumstances and the fact.
Okay.
So if the totality of the circumstances and the fact would reasonably lead you to that conclusion, although you're not sure, I guess that's what the second element of whether you make the statement knowing it to be false or the reasonability of your conclusion not believing in its truth. So if the totality of that decision is that if I put everything together, it is reasonable to believe.
You are being too much of a lawyer in this matter. Looking at all the gray areas and the cracks in this whole situation. But I'll hear Chumesi first.
So you see, my challenge with the questioner is you admit that at the time when you were making those depositions under oath, you were not sure. So if you were not sure, then why make a positive assertion?
Under oath.
Absolutely.
Because if you're not sure, you could have just said that to the best of my knowledge.
I don't know,
or this is what I know.
Right.
Because
but if you make
you
a
are
positive
testifying that it shall be the truth.
But
the whole truth.
Let me ask,
not partially true.
If he then goes to say, to the best of my knowledge, I know this to be true, would your conclusions be any different?
It would be different.
Absolutely.
Because then at that point, the persons made the deposition based on the knowledge they had at the time. Subsequently, they have come to a different knowledge. So at that time, their knowledge was this. Now
but
this
if
is
you
their
are not
knowledge.
sure, do you even
No,
know?
but that's exactly the point I'm making. So you see, at any point in time, of course, the ideal, which I'm sure as lawyers and public officers of the court, we all do not make the statement when you're not sure. Confirm.
Because you don't know. Once you're not sure, you do not know.
That's the
it's
thing.
about certainty.
But it's also possible that you do not know, but your witness statement has to go. In that case, you ideally say, to the best of my knowledge. You probably say, to the best of my knowledge.
It is still not to the best of your knowledge, because you do not know. That is not best.
That's the point. Once you don't, the difficult, we don't know the exact deposition the person made.
Absolutely.
But the moment you came to the conclusion that this piece of information I am not sure whether it is A or B, you should have stopped.
Yeah, go and check. So
because anything else you say, you are moving from the realms of what you know to the realms of speculation, which is not permissible.
Conjecture, absolutely.
So now, you have perjured yourself in court before some public institution officer. It's established. What are you likely to face?
So based on the law, once it's established that you have committed the offense of perjury, and like my colleague said, perjury is ordinarily a second-degree felony. It can come with a custodial sentence, which is you going to prison, or a fine, or both. And there's a rare instance where it becomes a first-degree felony, and that one you can go in for as long as the rest of your natural life.
Yeah.
So that is it. So it's not like when you go to court, you're at liberty to say whatever it is you can say with the hope that, nothing will happen. If it turns out that whatever it is you said, you knew it to be false and you said it, there are consequences, and you can either go to jail, pay a fine, or both.
Lying will hurt you one way or the other, and especially where it's on oath.
Yep.
Your freedom is at stake. This has been our show. Goodbye till next time. My name is Noella Seidu, and today with me on the show has been Yao Sompa and Randolph Chumesi Yankra. Till next time, goodbye.